All right, good afternoon, everyone, and welcome. I hope you can hear me. My name is Hiro Aragaki, and this is the second session of the UC Law San Francisco 2023 ADR Speaker Series. I am the new director of the Center for Negotiation and Dispute Resolution here at UC Law SF, formerly known as UC Hastings College of Law. We have a very special guest with us today, Professor Catherine Rogers of Bocconi University in Milan. You will all agree, I think, that Catherine really needs no introduction. She is one of the preeminent scholars of international arbitration and has been a trailblazer in so many different ways, from practically inventing the field of arbitration ethics to founding Arbitrator Intelligence, which in my view represents a paradigm shift, really the conversation around arbitrator appointment and also issues of diversity and equity and inclusion in the field. Last but not least, Catherine is an alumna of UC Law SF, which is why we are especially proud and excited to be able to have her here today to present her new paper, Reconceptualizing the Party-Appointed Arbitrator and the Meaning of Impartiality. So Catherine's going to speak for about 20, 25 minutes or so, and then we'll have a Q&A. Those of you who are on Zoom, please raise your Zoom hand, and we'll call on you in order. Yeah. So without further ado, Catherine Rogers, welcome.
Well, I am beyond delighted to be back at Hastings, now UCS Law, which is where I graduated, of course. And this room is absolutely magnificent. Unfortunately, people on Zoom can't see the amazing view and the beautiful sunshine. It's a gorgeous day here in San Francisco. I'm also particularly excited to be able to present a paper that's been sort of long percolating in my mind and on the computer as I redrafted, but it is finally coming out soon in Harvard International Law Journal, and I'm excited about that as well. I also love talking to people about it, including we just talked about it in the seminar, but I always learn something from people's questions. Unfortunately, now it's far enough along in the publication process that I hope I don't go, oh, I wish I'd written it that way or changed that or added that. So with that, it is sort of a baked product, even though there's clearly lots more to do, I think, on the topic. The premise of the paper, which I think most of you are familiar, is arbitrators in international cases are appointed on three-person tribunals. Okay, and typically what happens is each party appoints what's called a party-appointed arbitrator, and then the two generally, oftentimes in consultation with the parties who appointed them, will decide on a chairperson, and that's how the tribunal is constituted. In recent years, though, there's been some question of whether a party-appointed arbitrator is even an arbitrator. And there are a number of cases where there have been some very naughty party-appointed arbitrators that have helped raise questions about them. But there's been a more general critique based on some very specific cases, but also sort of a general skepticism. Can party-appointed arbitrators meet the minimum requirements of impartiality that's required to be an adjudicator? Okay? And the mere fact that they're appointed by one of the parties suggests that they can't be. Okay, because the party appointed them thinking, believing, hoping, with some basis, that they're going to rule in their favor. Okay, and so in fact, within the international arbitration community, there's been huge critiques of party-appointed arbitrators. Is the term an impartial party-appointed arbitrator an oxymoron, contradiction in terms? Is it just naive to think it's even possible? Is it just a triumph in rhetoric and marketing for the international arbitration community? Is it a fiction? Is it an ideological facade? And these are all terms, not mine, but those actually leveled by people in the international arbitration community. And they've led more than one person to say, actually, what they really are is just a farce. Okay? And of course, when there's that kind of a provocation, it's really interesting to me. And so I tried to respond to the deep question, you know, can we have something called impartial party-appointed arbitrators? Can it really exist? Is it really a farce? And that's the kind of sort of underlying inspiration. And I should add that parties are addicted to in the international context, to party-appointed arbitrators. They're not going to be eliminated anytime soon. even if the critique is coming from within the House, right? And so I think we need to figure out what they mean and how they can be legitimate or perceived as legitimate, or we're going to have a really big crisis in legitimacy of the entire system. There's a lot in the paper that I can't cover in the presentation, so I'm going to try and concentrate on maybe the more provocative, more interesting, but you're welcome to ask questions on any other part of the paper. So I want to start with a basic assumption or statement that we know and we deny at the same time. Okay? We know that absolute impartiality does not exist, cannot exist in a human being. If you wanted to resolve a dispute with a truly absolute impartial process, you could flip a coin, you could roll dice, but you couldn't have any humans involved. Okay? Some people think AI is going to be that, absolute impartiality. I will, different paper, say it's not even desirable to have a truly an absolute impartial arbitrator or decision maker. The whole part of the paper talks about the linguistic problems and talking about this. I won't go into that there. But what I want to talk about is a little bit is legal realism. We all know in our hearts what legal realism is, even if we don't know what that term means. And there's a very famous phrase that sort of captures it. It's a very demeaning to the legal system, right? That the law is what the judge ate for breakfast. The idea is that law is indeterminate. There's no single right outcome that for any particular case, but there's always some discretion that comes into play. And there are a number of variables that affect decision makers, judges, or arbitrators, okay, in playing in that space of indeterminacy. Okay? Now, and we know that that happens, but we deny it at the same time. Well, one thing that empirical research has done is demonstrate to us that we can't deny it so easily. So this was kind of a quip many, many years ago that led to development of legal realism. But here's an update on it. As it turns out, it's not what the judge ate for breakfast. This is a study of Israeli judges in the sentencing context. Okay? And we see, the higher up is the more favorable to defendants. So in the beginning of, and this is time in the day on the x-axis. And you see these kind of radical shifts, right, that are clearly tied to the time. Okay? It's not that they loaded up all the good defendants in the morning and had all the bad, it's also, it goes up and down. So what explains this? Well, as it turns out, it's not what the judge had for breakfast, but when they had their snack and when they had their lunch. Okay? So we know that what I call extra-legal factors affect judicial decision-making. Here it's food, or kind of your glucose level, I suppose, right? But other times it might be your values, your political orientation, your experience, your ideological mindset. So we know it can't be absolutely impartial, but we cling to this idea, right, as we also deny it. And so the way this is framed in some of the literature is that we know extra-legal variables affect judicial decision-making, but it's kind of maintained as an open secret. Now, for those of you who are young and experienced the Trump age and the recent appointments to the Supreme Court, maybe you're like, actually, it's open, but it's not a secret. We all just admit. Anytime we report now on a case, we say who appointed the judge. Well, very few years ago, it wasn't like that. We actually did believe that even though there was a political process for appointing Supreme Court justices or other judges, that they acted with some degree of independence and impartiality. But it has been this kind of tension, this contradiction, this wanting to believe that law is impartial and administered neutrally, independently across the board. But we also at the same time know that it isn't. And that raises a number of political questions or philosophical questions that I can't answer here. But I think if we know absolute impartiality is impossible, it raises different, more nuanced questions. Number one, we know some form of bias is going to exist. Which ones are legitimate and which ones are illegitimate? Who decides which ones are legitimate and which ones are illegitimate? And then, once we at least have some agreement on how we, what the legitimate forms are, how do we police the boundaries between legitimate and illegitimate? And my animation was a little bit off, but which forms of bias are legitimate? Well, it depends. It depends on what you want the outcome of the case to be oftentimes, right? Or what your biased political perspective is. So we oftentimes impose on judges or on adjudication, well, that's the wrong outcome. We're imposing actually our own bias on it. We're measuring what we think was the right outcome by what we believe, based on our own internal biases, is the right outcome. And there might be some biases that we can say we all agree on, or most of us agree. Certainly racial bias is absolutely unacceptable. Gender bias, unacceptable. Okay, so we might agree that those are illegitimate, but then more nuanced ones, who decides whether they're legitimate or not? It turns out it's who appoints the decision maker, right? So if it's a Republican Congress, the Republican senators decide, are able to confirm only those judges or justices who they believe have the right mental orientation, the right biases that are going to rely on or tap into the extra legal sources that they believe are legitimate. Okay, and we know that happens because we know that that's, the fights in Congress, we've all seen them. So my theory is that the sin, and I use that on purpose to go back to this as a farce, all that, to tap into that kind of angst that it's somehow immoral what they're doing. Maybe the sin of party-appointed arbitrators is not that they fail to adhere to some ideal of impartiality. Maybe their sin is that they sort of outwardly personify the fact that one individual's or one group's preferences for extra-legal biases is then put on a tribunal. So if absolute impartiality is impossible, we go back to these questions. And I think, how do we go to this? We go to this last issue. If you cannot, remove all these biases, and whoever appoints the decision makers is going to be imprinting their biases into the decision maker or the tribunal, okay, then how do we prevent those biases from essentially delegitimating whatever the adjudicatory regime is, whatever the decision making is? And the paper basically has two solutions. One is you need to have structural assurances of impartiality in the process. And the way I suggest that that works with party-appointed arbitrators is that they operate as part of this structural assurance that the tribunal is impartial and that their process for deliberation is impartial, and increasing the probability that the outcome will be, again, impartial, in quotation marks, because it's a very complicated term, and that the ability to have structural assurances of impartiality also allows us to have a more nuanced understanding of what party-appointed arbitrators are and develop role-based ethical rules where we can actually criticize them if they violate them and not just say, oh, that's a farce that they could even be impartial. So let me show you a couple things that I think affect and differentiate the party-appointed arbitrator's role, their function on the tribunal, from that of the chairperson. Okay, I know I'm going really fast. I'm also kind of excited, so I speak more quickly when I'm excited. I hope I'm not speaking too quickly. So chairpersons have all sorts of powers that party-appointed arbitrators cannot exercise, and that would be considered inappropriate if party-appointed arbitrators exercise them. That these are procedures, essentially procedural functions that the chairperson can perform. I believe it defines their role as a chairperson. So a chairperson can issue interlocutory orders or time limits without even getting the consent of the party-appointed arbitrators. They draft the initial decisions usually. They arrange the hosting and arranging of hearings. Party-appointed arbitrators generally are not considered, it's not considered appropriate for them to do that. They preside, of course, over the hearings. They monitor, and this is something that's in the literature of what a good chairperson does, is they're supposed to monitor the balance between the two party-appointed arbitrators. And they manage financial matters in ad hoc proceedings. They're given a lot of administrative functions that are generally considered, unless intentionally delegated by the chairperson to the party-appointed arbitrator, this would be inappropriate for the party-appointed arbitrator to do. Why? If they're all subject to the same impartiality obligations, why couldn't they all do these same functions? Okay, it's because we actually don't think they have the same role. And I'll show you a couple of examples that give away the fact that we have in our minds, even if we don't express it, a slightly differentiated idea of what the role of the party-appointed arbitrator is. So the party-appointed arbitrators, what I argue their role should be defined, and I'll come back to some of the literature describing this, is they should provide representativeness on the tribunal. Now, representativeness is not the same as representation. Representativeness is, I want my view of what justice is, in this case, represented on the tribunal. We talk about this all the time when we talk about the judiciary and the lack of diversity. Okay? We need to have women on the judiciary because in certain matters that can actually affect or correlate with outcomes, but it also legitimates the judiciary if a huge segment of the population is not excluded from it. In the same way, representativeness on an arbitral tribunal in an international setting provides that kind of assurance. The party-appointed arbitrator provides a check on the majority. Maybe this is what we were talking about before. If the majority is just kind of goofing off or being lazy or misses something, the party-appointed arbitrator, sort of acting, with an instinct because they're the party-appointed arbitrator, can check the majority on that. But they're also a counterbalance. So if the mistake is going in one direction, that party-appointed arbitrator can come in and say, whoa. But if the mistake is going in the other direction, right, so they sort of counterbalance each other in the same way that a sort of structural engineering counterbalance might work. Now, the fact that they have these different roles, which I think is hard to deny when you look deeply at how the procedure works, results or should result in an acknowledgement that they have somewhat different ethical obligations. And in fact, there are some that we know of. But this is denied in all the rules. All the rules say, no, all arbitrators have the same ethical obligations of impartiality. And I highlighted some of the words here. No, they're all the same. All their ethical obligations are the same. But we know that, or we say that, but we also know it's not true. Okay? Why? Because we have, if we differentiate, okay, and we say, look, party-appointed arbitrators, yes, they have an obligation of impartiality. I'm not saying they don't, but there are some differences. And one of the things that these differences, if you acknowledge that, is it actually helps facilitate, number one, a clearer definition of what impartiality is in that context. What should we really expect of party-appointed arbitrators? Not some farcical idea that we know isn't really true, but should we actually demand of ethical party-appointed arbitrators? This, in turn, gives us an opportunity to condemn inappropriate conduct, to label it as inappropriate and condemn it, not just condemn the entire process of party appointment. Okay, but having a role-differentiated definitions of ethics and, in particular, impartiality justifies existing practices that otherwise make no sense. So, as it turns out, when you are going through that process of appointing the chairperson, all ethical rules and all treatises say when you're appointing your party-appointed arbitrator, you can interview them. When they're agreeing on the chairperson, it's the one exception to ex parte communications. You can actually communicate with your party-appointed arbitrator after they've been appointed with respect to the appointment of the chairperson. But you cannot have ex parte communications under any circumstances with the chairperson. So we have differentiated ethics for chairpersons and party-appointed arbitrators, which wouldn't make sense if they actually are all subject to the same impartiality obligations, right? In addition, and this is not universal, but the ICC, the International Chamber of Commerce, has a rule that says the chairperson may not share the same nationality as either of the parties except in exceptional circumstances and with the consent of the parties. Okay? Now, why would you have a rule like that? Well, it's because you assume shared nationality has a different implications for impartiality, and that it's okay if it's the party appointed, but it's not okay if it's the chairperson. In other words, that rule by the ICC both acknowledges that we have differentiated standards of impartiality, but other parts of the ICC rules say, no, they're all subject to the same impartiality obligations. In the paper, I go into why this is partially attributable to the language, that it's very difficult to talk about different types of impartiality when it's a binary phrase, partiality, impartiality. The other thing that I think that developing a more clear and conceptually coherent definition of party-appointed arbitrators' role and hence their ethical and impartiality obligations is that it also helps explain what we just talked about. Why would the chairperson only be entrusted with making physical reservations for where the hearing is going to take place? It's because you're worried that if the party-appointed arbitrator does it, they might try to create a home court advantage. Why can the chairperson issue orders on time extensions unilaterally, but the tribunal, the party-appointed arbitrators can't? It's because we know, at some level, that their impartiality, what's expected, and how they actually behave is different. So we were talking before, I'm not arguing for a change in the role of the party-appointed arbitrator. I'm saying let's reconceptualize how we think about them in a way that is more realistic, more consistent with what they're actually doing and what our actual expectations are. If we have a more realistic conceptualization, we can come up with more clear ethical rules about what is permissible in that differentiated role and what isn't. And so instead of dismissing party-appointed arbitrators as simply a farce, we can say, no, this is bad party-appointed arbitrator behavior, and this is consistent and good in reinforcing structural impartiality on the tribunal. So it also justifies, I won't go into it because I'm extending my time, dissenting opinions, which is a part that's discussed in the paper. So I thought people online would want to see the beautiful location, so I wanted to end with that, and then thank you.
Thank you, Catherine. So any questions from the audience in-house? And then maybe we could see the Zoom participants too in case they've raised their hands.
Zoom.
Yes, please go ahead.
Oh, that's not what I was supposed to do. Sorry. I was trying to pull up the Zoom. I don't know how to do it. Yes.
Well, first of all, I love the concept of looking at thinking this in terms of sort of ensuring the structural impartiality of the tribunal. At the same time, by identifying and articulating different sort of functions and then the ethical rules that flow from those different functions between the chairperson and party-appointed arbitrators, is there some risk that we are now heading down a slippery slope that is eventually going to lead to aggressive parties and wanting to see their party-appointed arbitrators as advocates, back like the old days in the U.S. before the ABA, AAA ABA rules got updated?
Change the rules. So I think what it will do instead is allow us to identify when a party-appointed arbitrator is on the wrong side of that line, is down the slippery slope. Right now, we have no measure for evaluating that other than just writing off party-appointed arbitrators as a farce. You also should have introduced yourself because this is Peter Newman, who teaches ethics and international arbitration at Pepperdine. So he's speaking from a very informed view.
Not at all. It's the whole field is just a hopeless mess. It's anarchy. So I came here for enlightenment.
So there's a part of the paper where I think your question, I think, implies that impartiality exists on a scale, a sort of sliding scale. And we have like super impartial people and then naughty little party-appointed arbitrators at the other end. And in the paper, I talk about a more nuanced understanding of role-based impartiality. And the example I give is, and it's based on a couple of philosophers who write about impartiality as being role-based. And the examples they give are, you cannot know what your moral obligations are to feed a particular child, let's say, unless you know your relationship, your role vis-a-vis that child. So if you're the mother of that child or the father of that child, you certainly have an ethical obligation to feed them. If you pass them on the street, maybe you have a higher obligation than if they're on the other side of the world. But you can't define the ethical obligations until you know your interrelational role. There's another philosopher who's actually applied that in the context of impartiality and says, similarly, you cannot know. There are different kinds of impartiality. It's not a unit, it's not a linear scale. There are different kinds, kind of more three-dimensional. And the example he gives is if you have a woman who's on a law faculty and head of the hiring committee who is also a mother. Well, she has two different sets of impartiality obligations. One is to her children, and she must be impartial as among them and treat them all equally regardless of their merit. But on the hiring committee, she has to start from a position of impartiality, but she actually ends up having to be partial to one based on their merit. Okay? And so we wouldn't say, that one impartiality is stronger or better than the other, but they are the nature, the kind of impartiality is defined by the role, mother, head of the hiring committee. And in the same way, I think what I argue is that we don't actually assign the exact same role to party-appointed arbitrators that we assign to chairpersons, even if we pretend we do. And linguistics, we fall over a lot of linguistics in this. One, impartiality is a binary term. You're partial or you're impartial. It doesn't linguistically allow for kind of modulated kinds, number one. And number two, unlike the mother and the head of the hiring committee, they're all arbitrators. So they all have the same name, which again makes it harder to say, well, this kind of arbitrator versus this kind of arbitrator. But I do believe that their roles can be differentiated, and that differentiation is an essential first step to being able to define meaningful ethical obligations. I'll put one footnote here, which I think maybe addresses your concern about a slippery slope. I'm not talking about a radically different, completely diametrically opposed definitions of impartiality for one versus the other. Clearly, there's a very big core commonality. But I do think we need to make some allowances for some differentiations that, as I say, explains existing differences that we acknowledge and legitimate in the rules. So the differentiation's more at the margins than at the center, which I think maybe addresses your slippery slope concern.
Thank you. So I see that Mac has his hand up on Zoom. Mac, do you want to introduce yourself before you ask the question, please? You're muted.
My name is John MacArthur, and I'm an arbitrator based in Berkeley, but I do a lot of energy arbitration, mainly out of state. And in that industry, party-appointed arbitrators are common, and I've often served as them. And it struck me that over the last 10 to 15 years, both under the AAA, ABA ethical rules, and in practice, the model of the party-appointed arbitrator is once you've got the chair, you're neutral, and usually there's a feeling out process of the party-appointed arbitrators to make sure that the other guy or woman really means neutral. But some of the archetypal things you discussed, like discovery motions, in fact, often the chair will involve the party-appointed arbitrators. Drafting the award, often that'll be divvied up among the arbitrators if the panel isn't split. And I've been trying to fit onto the kind of ideal type that you have, how what I view as the more modern neutral party-appointed arbitrator role fits into that.
So it's a good question. I was actually just in Texas at an energy arbitration event, and I agree with everything you said factually, that I think there's a shift. Certainly, for those of you who may not know, in the United States, we used to literally have something called non-neutral, which makes this whole argument harder for people who know that history, non-neutral party-appointed arbitrators. And then in 2004, the AAA, ABA rules changed for commercial arbitration and said, no, they should all be neutral. And I think I guess I would have two responses to your comment, which is one, I think there's a realpolitik. I think there used to be this idea that you wanted as aggressive a party-appointed arbitrator as possible. And now I think there's a sense, and I have this in the paper, that overly aggressive party-appointed arbitrators undermine their party's interests and there are many anecdotal stories of the aggressive arbitrator at the hearing either offending the chairperson and then having them kind of side with the other. There's even one story that's been told at some conferences where the council literally saw the other tribunal members kind of physically leaning away from this obnoxious arbitrator. And so it's both, there's a sort of short-term solution which I think has come into play in reining in arbitrators, and that is that they become less effective. And then longer term, if you know your kind of rabidly partisan party-appointed arbitrator is going to be less effective on a tribunal, they get appointed less. They certainly are never going to get appointed as a chairperson, I think, and you're less likely to recommend them or to support them or to recommend them to your client if you know they're going to ostracize the other, it's not ostracize, but offend the other members of the tribunal. So I think we call it more neutral party-appointed arbitrators, but I think it's almost a more mature approach to party-appointed arbitrate, to fulfilling that role, and a more legitimate approach. And that I think the fact that you behave neutrally itself encourages you to continue behaving neutrally. But there are moments, I think, when a party-appointed arbitrator, can legitimately be more cognizant of the perspective of the party who appointed them. And I would say it happens more organically. So, if you are an oil producer, you probably appoint a party-appointed arbitrator with a background in oil production versus purchasing. And so they're not cognitively or intentionally being biased, but their background sort of inclines them, orients them to one perspective or the other. And they don't behave obnoxiously, but they still end up being, I think, a check when the tribunal leans towards a view that is inconsistent with what their sort of natural proclivities selected by the party are. I think that answers your question. If I didn't, feel free to ask it. I'll follow up.
No, I think that largely answers it, and it reminds me under the old non-neutral view, one of the justifications was, well, if you're a non-neutral, you have a right to step in if you think the party that appointed you, their position is not coming through clearly. That was part of what was expected, quote unquote. Yeah,
but I think that's a good thing, because we were talking earlier in class, there's no appeal. So if the tribunal gets it wrong, you're stuck with it. And it's good if somebody on the tribunal sees it as their role to make sure to sort of act as a quality control person when the tribunal's kind of going in a wrong direction or what they perceive as a wrong direction. Thank you, though.
Looks like we have a question from Gary Benton.
Hi, Gary.
Hi, how are you? I don't know if I'm visible on the screen. I am. Oh, let's try this again.
Yay.
Yes.
Can you see me now? All right. Well, first of all, hello to my former law firm colleague, Professor Rogers. It's great to see you, and thank you. I'm sorry I couldn't be up there in person. I'm Gary Benton. I'm a U.S. international arbitrator in Silicon Valley. And Catherine, I really enjoyed your presentation. I have to say, I think I must live in a slightly different world, and that is because in all of the arbitrations that I've been, or I have to say maybe almost all of them, I do think that I see arbitrators who try to act quite professional and be neutral in their handling of the cases. That's not to say, as you're suggesting, that there might be some perhaps bias that is unconscious that comes out. But I do think we underestimate in this discussion the importance of having a chair who can really rely upon the co-arbitrators, and that as a group, as in terms of a dynamic, that they're all acting professionally together. And if we go the step of saying that the party-appointed arbitrator is automatically biased, I think that does take away from some of the quality of the decision-making that's to be done. So I'll just offer that thought, and I'd love to hear your thoughts on that as well.
Yeah, I think we're not in disagreement. I think it's really a language problem. So, and the word, another reason why this is very difficult to discuss is that not only is biased and unbiased, partial and impartial binary, when I argue that it's sort of multifaceted and that those are too simple of a term, but it's also very loaded. It's incredibly loaded language. I mean, who wants to be partial or biased? Okay, so I sometimes use words like inclination or things that are a lot softer. They don't sound as critical or as unethical, to be honest. And so let me give you an example from the paper of some of the types of quote-unquote bias that I'm talking about. So there have been some empirical studies that have, for example, identified. Actually, all the empirical studies that conclude, or the two empirical studies conclude, that any dissenting opinion by a party-appointed arbitrator is always, quote, in favor of the party who appointed them. And they say, well, that just clearly shows that there's bias there. And another study actually did an experiment where they gave a bunch of arbitrators vignettes. about cost, asking them to award costs to one of the parties. And some of the experiment subjects, they told them they were appointed by one party, some the other party, some they told them they were appointed by, by an institution, and some they didn't tell them how they were appointed. As it turns out, there was a strong correlation between the amount they were willing to, how they awarded costs, and whether they thought they were appointed by one party or the other. And they say, well, this is an unconscious they call it an affiliation bias, that the fact that you're appointed by someone sort of suggests. In the paper, that's even, I critique these as very misleading in many ways, because yes, if the only thing you know is that you're supposed to award costs and you're appointed by one party, that's the only information you can act on. But the world and cases are much more complex, and people are more complex. So we are all, I think the phrase I use in the papers, we're all a bundle of, I don't even like the word, but cognitive biases. We are all the products of our experience, our perspectives, our values, our experience, our training as a lawyer. And professionalism, I 100% agree with you, can help confine some of the, can remind us to kind of constrain some of those, as can procedures. We talked in the seminar before about how procedural rules can also constrain a decision-making to kind of keep out some of these inclinations. But I think what I'm suggesting as bias or kind of party-appointed arbitrator bias, again, that word, is that the parties choose their party-appointed arbitrator based on as extensive research as they can do to determine that the person they have selected has unconscious biases or proclivities, whatever you want to call it, that align with their perspective of the case. So the oil producer, picks someone who has a history of being general counsel for an oil producing firm, rather than, or an IP property, rights owner versus a purchaser. They just come from different backgrounds. They're used to arguing, making certain arguments. So it's a subconscious kind of bias, and bias is the wrong word. It's legitimate. It's fine. You have a perspective based on your experience, and that's why the parties choose you. So I'm not saying that they should be free to just give in to those, but I think we need clearer rules about how and when they can and should exercise and kind of give voice to those proclivities. I don't know if that answers your question, because I have the feeling you thought we were really on different sides. Have I persuaded you at all?
No, we're always on the same side, I'm sure of that. So thank you very much.
All right. Thank you. And next time I come, we will make sure we see each other in person.
Absolutely.
So let me ask you a question, Catherine, in the hope that this will inspire some of my students to also step up and ask some more questions. So you've said in the presentation, and you say in your paper, that you're not proposing a change in the role of the party-appointed arbitrator, but rather a reconceptualization of the role. And so I wanted to kind of push you on this a little bit, because I wonder whether really the reconceptualization, and we talked about this, at the break, has more to do with the idea or the concept of impartiality itself. In other words, not just an abstract notion of what impartiality is, but really a context or role-dependent conception of impartiality. And the reason I say this is that, you can say, well, we're reconceptualizing this always already biased party-appointed arbitrator as actually potentially impartial, right? Mm-hmm. Because everyone is biased, but that doesn't mean that you're going to be partial. Right? But it sort of begs the question, because it doesn't necessarily mean they're actually going to be impartial. They could still be partial and not impartial in many different ways. And so I guess I wonder whether it ultimately does come down to the role. And the reason why is that when you talk about the devil's advocate in Janus's theory, he's talking about kind of designating someone consciously to be the devil's advocate, right? I think there's another passage where someone is talking about, designating them to specifically take a contrary position, being charged with that responsibility, doing it in a low-key style while withholding their own opinions and not being too confrontational. So I wonder whether ultimately the question of whether the always already biased impartial arbitrator is able to be impartial has more to do with the role, actually, than just reconceptualizing them in this way.
Yeah, I mean, I think, so yes and yes and yes are the short answers. The slightly longer answer is yes. My theory of ethics generally, it really is that ethics is role dependent. And that's part of why, for example, German attorneys, even though they're also attorneys, have radically different ethics rules than American attorneys. It's because in the court system, U.S. attorneys are assigned a very different role than German attorneys. And so you can't just swap the ethics. And you can't judge one by the other. That wouldn't be fair. Now, with the 3 arbitrators on the tribunal, the role differentiation is much more narrow. It's much more subtle. But I believe, as I showed in my slides earlier, I believe it exists. And I believe we all agree it exists. We just don't admit it because we call them all arbitrators. And because there's something icky about saying, well, the party-appointed arbitrator is somehow less impartial. And I think, and when I say reconceptualization, it's like, well, instead of just saying they're less impartial, let's talk about a different kind or slightly different nuanced applications of impartiality that are more consistent with the role we actually assign them. So the reconceptualizing is, I'm not suggesting we should change the way party-appointed arbitrators operate or change their ethics rules. I'm actually saying we already implicitly apply these ethics rules to them, the ex parte communication, but we talk out of both sides of our mouth, just like with judicial appointments. We see, we know that we're really appointing this justice, or we're supporting the appointment of this justice because he or she is pro or anti-abortion or whatever else. Okay, we know that in the appointment process. And then when they're appointed, they're supposed to be absolutely impartial. Well, we appointed them precisely because their proclivities agree with ours. And the same thing happens with party-appointed arbitrators. And I think that that's a good thing. Because if none of us are capable of absolute impartiality, we just have to think about, okay, well, how are we going to manage the fact that everybody is at some level partial? We're incapable of being impartial, so what do we do with that when we have this ideal of impartiality? And to me, the tripartite tribunal is a structural solution to that. You're sort of counteracting one potentially, and it's not, immoral, inappropriate behavior, but the proclivities that had one party this party-appointed arbitrator are sort of counterbalanced by the proclivities of the other. And the other function I didn't really mention in my remarks is that in addition to all of our personal cognitive biases, we also have group-based biases. We're influenced in our decision-making. This is not a surprise. I'm not telling you anything you don't know right now. We're influenced by people we're around. And so they've done studies, actually, that people who have overweight roommates become more overweight than other people down the hall, right? So we're always influenced by people we're around. Groupthink is a specific kind of influence, and the definition is when you have a group of people who are have civility norms, who have norms of cooperation, which in international arbitration is always affirmed to have very high civility norms, that there is a reluctance to start a fight when you disagree. Okay, so you don't want to contradict your colleague who you might be working with in the future. Now, arbitrators, collegiality is actually, an important professional credential and necessary to advance. Why? Because you're appointed by other people in the field, right? So norms of collaboration supplemented by personal incentives mean we have bodies that will want to render unanimous decisions, have unanimity in their decision making, meaning they might be reluctant to say, wait a minute, I think you've made a mistake on this fact. Or if not a mistake, I think the party who appointed me would see that really differently, and you've failed to consider that view. And so in Yanis's theory, the solution to groupthink is a devil's advocate, and he suggests you would assign that role to people around the room. I argue party-appointed arbitrators on a tribunal function the same way, that when the majority is kind of leaning away from a position they think might be what the appointing party was, wanted them to represent on the tribunal, would say, wait a minute, you haven't considered this position. But then when the majority is leaning the other way, the other party appointed arbitrator. So that's what I think creates this kind of structural, procedural impartiality that is the best way we have to deal with the impossibility of actual impartiality in human beings, even if they're called arbitrators. And I agree with Gary, somewhat constrained as best they can be by their professional norms and training. Yes?
You did mention the different approaches and maybe professional values that German attorneys have, for example. A bright of this very fractious world as increasing sort of not uniformity, but sort of harmonization of views and values and ethics and international arbitration. Now, in the course of your research, to what extent did you encounter and try to come to terms with cultural influences on conceptions of independence and impartiality?
Yeah, so that's a
And do you feel that in terms of the thought leadership group, the elite in this area, to what extent do you feel that they have brought in enough voices from different cultures?
And so that's a great question, and a really important one for, the whole, I think, premise of international arbitration is that it can accommodate and facilitate fair and legitimate cross-cultural adjudication. And so much of what we believe is justice or fairness is actually culturally defined. We don't know that because we're like fish swimming in water. We don't realize we're in water. But when you go to another culture, you realize they have really different ideas about what's procedurally fair. And there's an example I cite in the paper, which is, it's actually a non-diverse tribunal, and they had a witness who testified that it was relevant what the color of something was, and the witness was asked and said, well, that's yellow. It was yellow. The tribunal said, well, clearly this witness is unreliable because that was just not true. It was orange. And the author, Juan Kadani, who is originally from Ethiopia, now a law professor in the United States, said actually in many parts of Africa, the definition of yellow expands in a much broader spectrum to include shades of orange. And so, in fact, the witness was accurate. But, and you wouldn't know this, and so when I talk about cultural biases or cognitive biases, it's a bias to think that, this person's, that yellow is yellow. We don't realize that that's a bias because in our culture, yellow is yellow. And we don't even realize that another culture might have a different view. And the point of Juan Kadani in that example was if they had appointed if there was an African arbitrator on the panel, probably as a party appointed, that person could have, when the tribunal's leaning towards this idea, oh, this guy's a liar, they could have said, wait a minute, you're not considering the fact that actually in my culture and in this person's culture, that would be considered under the label of yellow. So when we say, and that maybe makes it sound a lot less provocative to say we're all biased, right? Yellow's yellow. We're not biased, we don't think of ourselves as biased by, identifying a color. But even something as simple as that can actually be culturally determined. And then when you get into more nuanced questions, contract interpretation, how do you do business? And there's a lot of culture that gets loaded into that, and we don't realize that we might be biased. But if you have this kind of devil's advocate on the tribunal, they can point that out. And that's, again, super important when you have a system where there's no substantive review on appeal. That's how one of the most important controls we have for judicial bias, certainly at the trial level, right, is appellate review. If the decision is produced, it's a little bit of an oversimplification, but if the decision is produced by bias as opposed to an appropriate application of facts to law, that can be reversed on appeal. That's not the case with an arbitral tribunal. Yeah. Sorry.
Sorry. Was anybody else?
No, I think he was supposed to.
So if we're accepting that legal realism is a real phenomenon, and that's something that we're all living with, and we'll continue to live with, I guess I wonder if the solution isn't to write extra rules to standardize how arbitrators deal with impartiality and bias, at least on the party side. How can we then trust that the chair is going to corral that? Because is it now turtles all the way down, essentially?
So it's a great question, because what really ends up happening, and the arbitrators, I think, can weigh in on this, but it really ends up almost always being, the chair agrees with one party appointed arbitrator, and the other party appointed arbitrator either goes along or maybe, in pretty rare exceptions, writes a dissent, or they negotiate to kind of maybe get some concession on something else if the outcome's going to be that way. Chairpersons, even though we call them impartial, right, they also are a bag, of a bundle of cognitive biases. And that's also why I think the party-appointed arbitrators are so important, is because they also kind of balance the chair, right? And they force the chair to see past his or her own biases as well. And that's why I think your question answers the other question, how do we deal with cognitive biases? If impartiality is impossible, isn't that also a problem for the chair? Yes. How do you solve that problem? I think party-appointed arbitrators solve that problem. They help avoid the idea of the chair, in a sense, being blinded by their own, hidden bias, hidden proclivities, let's call it. Yes.
I'm Donna Aldi. I'm an international arbitrator based here in the Bay Area. So I kind of have a question. So maybe kind of stepping back. So this decision-making process of who the party is going to appoint. Looking at things today, right? You're looking at businesses that have an in-house counsel, and nowadays that role of the external counsel that's running the arbitration, and that balance of power, I don't want to say really power, but kind of that relationship between the in-house counsel and now the law firm counsel. How is that playing into who is actually now being appointed as a party appointed arbitrator?
It's a very good question. It's a very good question. And I've written elsewhere, that although I think lawyers in this field, the reason I'm in this field is because I have tremendous respect for them. And I think they do, generally, they're amazing advocates in terms of quality. But I do think, it is a very tight-knit field. It is, one type of cognitive bias that's been proven to be particularly resilient is the reciprocity bias. When someone does something nice for you, you have this deep instinct to reciprocate, which is part of what probably creates a sort of leaning of party-appointed arbitrators, type of reciprocity at some level. But one of the things that creates a risk of, right, is if someone from this law firm, I will give you it by way of anecdote rather than hypothetical. I had someone tell me that, arbitrators, there are rules that say if you've been appointed more than 3 times in 2 years by the same law firm or the same client, slightly different rules, you must disclose those prior appointments, because repeat appointments might be something that raises a question of bias. You have to disclose it. And I had a partner at a major, very well-respected law firm, and I respected him tremendously, say that they had a client that they were saving this arbitrator for. And so they didn't recommend it to the client whose arbitration came up first, because they were saving the arbitrator so they wouldn't have to disclose it by recommending the arbitrator in a subsequent case. I'm not going to discuss that example, but in terms, I will say this, which is the incentives of the law firms and the knowledge of the law firms and the in-house counsel do not always align perfectly. And that creates some challenging dynamics. And you can imagine when we talk about the reciprocity, right? Well, maybe I also don't recommend this arbitrator because I'm rivals with that person. Or maybe I do recommend this arbitrator because they appointed me in another arbitration. And I think that probably also exists at some level among in-house counsel, especially those who manage their own cases. But I do think that that's a subtle background issue that raises nuanced questions of ethics for some outside counsel. I end up when you write in this area, you end up hearing lots of stories that that you couldn't, of course, share in a context like this, but that do raise nuanced questions. So I think you're right that the interests and processes for appointing are not always the same with in-house and external counsel, for better or for worse.
Thank you.
Yeah.
Mac, you have your hand up. Is it a new question that you'd like to ask, or was it from before? Mac? So let me ask you maybe a final question,
okay,
because we are running out of time. So, there's been a lot of controversy now over the reform of investor-state dispute settlement. And so I guess I'm wondering, what are the implications really of your work and your paper for that debate and for alternatives to an investment court?
Yeah. So I'm sort of not directly involved in a lot of the reform processes, but one thing I think is this paper implies and became more explicit in the final version is the sort of revulsion and degradation of party appointment is is a little misplaced. So for those of you who don't know, the European Union and others have proposed replacement of investment arbitration, where state is one party and then investors the other side, with a standing investment court, with the idea that a court is so much more inherently legitimate because it's created by governments, because it has all the trappings of legitimacy, including the fact that the parties aren't picking the judges. Which is a little ironic because on the International Court of Justice, we have something called ad hoc justices, which is precisely because the parties want some input on who's going to be deciding their case. And I believe the objections in Working Group 3 to replacement of an investment court with replacement of investment arbitration with a court is mostly by smaller developing countries, particularly in Africa, because they realize if there were a court like the WTO or the ICJ, who's going to be able to put their thumb on the scale about who the judges are? It's going to be the most powerful nations. Yes, okay, there'll be a token, a few for some, but it's also a dilution, right? If you are an African party and you have international arbitration, you get to pick. You get to assure representativeness on this tribunal. You don't risk non-representativeness because there's a pool and there's sort of a random assignment of cases or something. And the pool, you had a small input about who's going to be in it, but not something very significant. And even in a context of investment arbitration or investment law, where the paradigms are shifting, there are different views in the North and the South, or the East and the West. So the idea that it's only states versus investors is an oversimplification, I think. There are differences among investors and there are differences among states. And I do think, the other point we made earlier, which is, I don't want to say standing tribunals are overrated, because clearly they have important and have done very important, great things, but also so have ad hoc tribunals. And one of the reasons, and maybe this is a good note to end with, everyone thinks that because an international arbitration tribunal is temporary and not government appointed and the parties choose the decision makers, that it's somehow inherently less legitimate. But I think there's something to be said for ad hocism. And I think that it's not an accident, by comparison, that for many years, when they were proposing this investment court, they pointed to the grand success of the WTO as the model. Look, this is the model international court, the WTO. The WTO is right now, defunct might be a word, or at least kind of in a holding pattern. Why? Because the U.S., of all countries, would not appoint the replacement judge to a member of the appellate body, the review body. And you might think, well, that was Trump. But in fact, actually, into the Biden administration, and the process for appointing judges or members of the appellate body has become itself quite politicized, according to insiders, again, cited in the paper. On the WTO, they're not just agreeing to, who's the most impartial decision maker we can pick. Let's put them on the WTO. No. Everyone who appoints a decision maker has in mind what the proper view within the parameters of professional impartiality is. And I just think we should acknowledge that and then respond to it structurally rather than deny it and play in this world of fantasy, perfect impartiality.
Great. Well, on that note, thank you very much, Catherine, for your presentation. We can continue the conversation at the reception hour. For those of you who are in person, thank you all for attending.